really thrilled that LDF is once again sponsoring our SCOTUS preview of the 2021 term, and they will be talking about civil rights cases before the Supreme Court this term. I want to say a very special welcome to Associate Director-Counsel Nelson, who is here with us to introduce the panel, to Mr. Spital, to Professor Wright, and also to Ms. Reed. We are thrilled that all of you are here this afternoon. So thank you again to everyone for being here, and please enjoy the event.
What I think is most interesting about a particular term is that it comes at a moment where it is probably one of the most contentious terms of the Supreme Court's history, not only because of the controversial decisions that the court is likely to issue in areas of critical public importance, like abortion and gun rights and redistricting, but because the court itself is under such significant scrutiny as an institution. We all may know that the president has convened a commission to examine the Supreme Court, the Presidential Commission on the Supreme Court of the United States, where it had a public meeting on Friday after summoning testimony from various individuals and institutions. And I'm proud to say that the Legal Defense Fund submitted testimony talking about the court. As you all may know, the Legal Defense Fund was founded in 1940 by Thurgood Marshall, who ultimately became the first African-American Supreme Court justice. And the court has been central to so many of the victories that we've been able to secure under law over time to help transform our democracy. But what we're finding is that there is a significant concern among many pockets of the public about the court's credibility, about its independence, its transparency, its diversity or lack thereof. And those are some of the topics that we touched on in our testimony to the commission to really examine this institution, because it is such an anchor for our democracy and is so critical to the rule of law, to ensuring that we are a nation of laws and not policy or random ideology, but there is some consistency and reliability and actual legal authority that binds us together. So in addition to talking about some of the cases that are so critical before the court this term, I'm hoping that our panelists will also describe what they think might be some of the more pressing concerns about the court itself that will no doubt come up through these cases before it. The idea that the court has a challenge in terms of neutrality and the presumption that we already know how the court may rule on some of these issues is of significant concern. There are also questions about how much deference the court should give, but all federal courts should give federal agencies that are interpreting federal law. And for example, in the case that's before the court now, and how we think about Medicare allocations. There are cases that challenge state eviction moratoria, vaccine mandates, COVID-19 orders. The power that rests in this court is quite significant. And as I said, all of this is happening against a backdrop in which the court itself is being questioned in terms of its composition and credibility. So it's with that very, very exciting and interesting and fraught trajectory over the next term that this panel is going to discuss some of these upcoming blockbuster cases. And you have a wonderful panel to guide you through that discussion. So I will turn over the mic to our esteemed panel to guide us through a discussion of this upcoming term of the Supreme Court. Thank you.
We're just going to jump right in and start talking about some of the biggest cases that we'll see. And I'll start with the one that I think most people are watching, and that's Dobbs versus Jackson Women's Health. And of course, this is a case that it's a direct challenge to Roe versus Wade and the right of women to terminate pregnancies prior to viability. Of course, this issue has been part of the legal debate for many, many decades now. Since Roe was decided almost 50 years ago, it has played prominently in Supreme Court confirmations, at least the last 4, because the concern was, and it is a valid concern, that the last 3 justices, Justices Gorsuch, Kavanaugh, and Justice Barrett, would provide critical votes to overturn Roe. And so I'll briefly sort of summarize Roe and later cases and describe what Dobbs is all about. So in Roe, the court held that a right of privacy flows from the Due Process Clause of the 14th Amendment's protection of personal liberty and its restriction on state action. While the Constitution does not explicitly mention any right to privacy, the court in Roe noted that it had previously recognized that the right exists and that the Constitution guarantees certain areas of privacy with respect to personal liberty. So, for example, the court had previously held that embedded in the 14th Amendment was some protection of activities related to marriage, procreation, contraception, family relationships, child rearing, and education. And all of this was held to be protected without express mention of it in the Constitution. So in Roe, the court found that this right of privacy protects a woman's decision whether or not to terminate her pregnancy prior to fetal viability. That is the point where the fetus can survive outside of the mother. A few years later, in a case called Casey, the court reaffirmed Roe and held that it established a rule of law that abortion care is a component of liberty that the court refused in Casey to renounce. And the court went on in Casey to find that while the state has compelling interests in potential life, health, and safety, those interests do not trump a woman's right to procreative liberty prior to viability. Casey therefore concluded that states cannot place undue burdens on women's rights to terminate pregnancy prior to viability. So since Roe and Casey, the right to abortion care has been under constant threat from states, namely states led by conservative legislatures. Most recently, just in 2016, the court decided a case called Whole Woman's Health that struck down a Texas law that it held placed undue burdens on women's right to pre-viability termination. Then in just last term in 2020, the court reaffirmed that in a case called June Medical. So now we are at Dobbs. After the death of Justice Ginsburg and the confirmation of Justice Barrett, the court has been asked by Mississippi to overrule Roe and Casey entirely. Mississippi enacted a statute that bans all abortions after 15 weeks, past the last menstrual period, long before fetal viability. Notably, the law does not make any exception for victims of rape or incest. Mississippi's brief to the court is pretty direct. It asks the court to let its law stand and attacks directly the reasoning of Roe. The state principally argues that the Constitution does not mention abortion at all, and so abortion is not protected, and therefore Mississippi's law need only survive rational basis scrutiny, which when you get to Common Law 2, for the students who are on the line, you will learn that that is the lowest level of constitutional scrutiny, very easy to get by, and that is what Mississippi thinks should apply to its law. On the face of this, the law is definitely unconstitutional. It is flagrantly unconstitutional, and it was passed to be unconstitutional to set up this case. And so that is what we are dealing with. This case will be argued on December 1, but we already have some indication of what the court is likely to do, because just a few weeks ago, the court, with all of the conservatives except the Chief Justice and the majority, refused to block a Texas law that bans abortion after 6 weeks. And so the court, in its very brief opinion, issued very, very late at night, blamed the outcome on procedural issues. But it's notable that they have overcome those very same procedural issues in other cases, although some of them were pretty novel. And that refusal to block that law, which is like the Mississippi law, flagrantly unconstitutional, tells us about where the court might come down on this issue. The Chief Justice, as he did in June Medical, did join with the liberals, but unfortunately, with the confirmation of Justice Barrett, that is not enough. There was still 5 votes to refuse to block this Texas law. And the expectation is that Dobbs will have a very similar outcome. I think the only thing that is up in the air is exactly what the reasoning will be. But I think it's safe to say that there are 5 votes to do significant damage to women's reproductive liberty that had been previously protected by the Due Process Clause. So I'm going to be going through these cases. Feel free to drop any questions in the chat so I don't feel like I'm just talking at all of you. If you have questions, please drop them in the chat and we promise we will get to them. The next case is about gun rights. And so the name of the case is New York State Rifle and Pistol Association versus Bruin. And this is a follow-on to two cases the court previously decided. But before we get to those cases, I'll give some quick background on the Second Amendment. So the Second Amendment states that a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. In 2008, in a case called Heller, the Supreme Court determined that this language encompasses an individual right separate and apart from any militia service to possess and carry arms in case of confrontation. Heller held that the use of the word bear in connection with arms means that the right to carry is in case of confrontation, and specifically to be armed and ready for offensive or defensive action in case of a conflict with another person. Heller invalidated a DC statute that prohibited firearm possession in homes. And so the court's opinion was limited to the right to bear and keep arms at home for self-defense. A few years later, after Heller, in a case called McDonald, the court held that the Second Amendment and the court's interpretation of that amendment in Heller applied to the states by virtue of the Due Process Clause. Heller and McDonald technically left open the question whether there is a right to carry arms outside the home. And this, as with the issue raised by Dobbs, has been a point of contention in the federal courts of appeals and in public debate for a very long time. This specific case arises from New York. So New York does not permit open carrying, that is the carrying of firearms where the firearm is openly visible and obvious to those around the carrier. But the state has a statute that prohibits concealed carrying of firearms for self-defense unless a state official finds that there is proper cause. And in order to meet that proper cause standard, the state has held that there has to be more than just a generalized need for self-defense that any member of the public might have. So living in a high crime area, for example, is not enough. There must be some sort of individualized threat to life or safety. 3 New York citizens who are trained and experienced with firearms applied for a permit to carry outside the home for self-defense, and they were denied. The Second Circuit upheld it based on a prior case called Kochalski, where it found that that licensing statute and the way that it works was constitutional and did not violate the Second Amendment. This case presents 2 questions. The first being whether the Second Amendment protects the right to carry firearms outside the home for self-defense. I think the answer, according to Heller, is probably yes. The problem with Heller, and this is pointed out in the respondent's brief, which was filed on behalf of the state of New York, is not just the textual analysis, and so divorcing the reference to a militia from the individual right, but also its methodology. And so in Heller, the court tied the scope of the right to the historical position of the right in 4 eras. So pre-colonial in England, the founding era, the antebellum period, and Reconstruction. And so the briefs in this case really read like history treatises rather than legal analysis. But that is what the court demanded in Heller. Finally, another thing about Heller that is problematic and might tell us where the court will go is that it spoke very broadly about the need for self-defense. And they related it to a natural defense. For self-preservation, to protect yourself from threat. And so it will be difficult for the court to say that that right exists in the home, but not when you step outside of it, based on some of the broader language in Heller. The second question is, to what extent, assuming that the right exists, states can regulate it? And so the primary problem, the weakness with the New York law, is not the regulation, because I do think there is a historical basis for regulating the carrying of concealed weapons, and the court itself pointed that out in Heller. But it's the existence of a great deal of discretion for state officials. And so state officials have a lot of discretion to decide who meets the probable cause analysis, and the amicus briefs on the other side, as well as some of the search stage briefing, points out that the result of that discretion is that folks like Donald Trump and Howard Stern have concealed carry permits, but women, for example, working late at night who feel vulnerable coming home from work do not. And so if the court were inclined to avoid the big issue, the Second Amendment issue, and I don't think they will avoid it, I think they granted the case to answer it, but it might come down to that feature of the New York law, because assuming that there is a fundamental right involved, there really is no basis for a statute that gives that much discretion to state officials. That's sort of the main backup argument that that the petitioners are using here. Finally, I will highlight a case called Thompson versus Clark, which is a really important case that was argued by Amir Ali from the MacArthur Justice Center last week. I encourage everyone to listen to the argument, those of you who are interested in appellate advocacy, because I think it was a prime example of a very, very well done argument before the Supreme Court. Thompson involves Section 1983, which I think the students will get introduced to probably in federal courts, if not a little bit in con law too. But Congress, just by way of background, passed Section 1983 as part of the Ku Klux Klan Act of 1871, with the goal of protecting Black people from state violence and other constitutional harms. The Supreme Court has, over the years, decided a number of cases that dictate the analysis for Section 1983 claims, including the expansion of qualified immunity, which is another issue that perhaps we'll get to later, but is relevant here. The court has held that a claim for damages for constitutional violations under Section 1983 requires identifying the common law tort that gives the closest analogy to the asserted constitutional claim, and then incorporating the elements of that common law tort into the Section 1983 analysis. This case has infuriating facts, and so I won't go too far into them, but you should all read the petitioner's brief in this case. A man was falsely accused of sexually abusing his 1-week-old daughter. On the basis of fabricated and falsified evidence, he was arrested. The charges were later dismissed by the prosecutor, quote, in the interest of justice. In similar cases, the court has made two determinations. First, the Fourth Amendment protects against seizures pursuant to legal process. That is, when police carry out an arrest based on false evidence, and the arrestee is subsequently detained because of that falsified evidence. Second, the court has held that the closest analogy under the common law in terms of torts is the tort of malicious prosecution. And one element of malicious prosecution is that the claim must have been terminated in the accused favor. This case, Thompson, involves what qualifies as a favorable termination. So to prevail on a 1983 claim, must the plaintiff show that the case was dismissed in a way that provides affirmative indications of innocence. The lower court in this case said yes, and that dismissal in the interest of justice do not qualify because it says nothing about innocence or guilt. Petitioner argues before the Supreme Court that this is wrong, and he is right, at least in my humble opinion. The purpose of favorable termination, according to the courts, is finality and consistency. And so avoiding a situation where the state says you're guilty and then a federal court in a 1983 claim comes out and says, well, you really aren't. And so to avoid that type of inconsistency and to have some comedy between state and federal courts, the favorable termination rule is one that applies. But it has little to do with innocence. And as the petitioner's brief points out and was pointed out at oral argument, it's very difficult to make that argument because, for example, what does a dismissal in the interest of justice means? A court would have to have a trial within a trial to determine whether, as part of that dismissal, there were indications of interest. And so it places an undue burden on plaintiffs. It is really unfair. It's too high of a standard to meet, and it's inconsistent with the historical basis for the favorable termination rule. And so this is a case that will have significant impact for Section 1983 plaintiffs and civil rights lawyers in the way that we practice across the board. So those are the three cases that I am going to cover, and I will turn it over to Sam now to pick up. And please don't forget to drop your questions in the chat so that we can answer them.
Thank you so much, Tiffany. I actually wanted to ask you one more question, if that's okay, before we go on, which is your analysis of Dobbs in particular. I think one of the things that I have always found really interesting and difficult about the sort of state of precedent with respect to abortion rights is that when now Chief Justice Roberts was sort of asked about this line of cases at his confirmation hearings, he said, I would actually start with the Casey case from 1992, which considered whether or not Roe should be overturned and did this stare decisis analysis the court is supposed to do, where it considers factors in addressing a prior decision and whether it should be reaffirmed, even if the views of the justices on the court have changed. And Casey said, after thinking about it, and for those of you who may not know, this has been a controversial issue for a long time, and a lot of people thought the court maybe was ready to overturn Roe and Casey, which was much closer in time to the Roe decision. And the court ultimately said no, that we're going to adhere to the previous decision. So from my perspective, at least, that makes this sort of current attack even more problematic from a rule of law perspective, because you already have had a previous court saying, no, from a stare decisis perspective, whatever you think about how controversial the issue is, or however you think it should have been decided the first time, we've decided as a matter of stare decisis, it has to stay in place. So I was just wondering, what your perspective on that is, and what you think as we, especially, sort of welcoming future members of the profession, what this kind of means as we think about the rule of law that some justices still seem sort of poised to overrule Roe.
Yeah, so I think I have three thoughts, and I'll try to keep them brief. But my first is, one of the most dangerous things about at least three of the conservatives on the court, I think, is that they don't believe in constitutional stare decisis. So because this is a question under the Constitution, we don't even have to think about stare decisis, because if, as a matter of interpretation of the Constitution, it's wrong, then it's wrong. It was wrong then and it's wrong now, and we should be able to say so. So I totally agree. And I read Casey last night and was struck by how much the court really grappled with this from a stare decisis perspective. Then you have Whole Women's Health, and then June Medical, where the chief on stare said, I also, because of stare decisis and legitimacy of the court, I'm going to side with the liberals on this. As much as I think it's wrong, and I think, Casey, Roe were wrong, this is the right thing to do as a matter of stare decisis. The problem is we now have 5 people who probably are willing to say, we don't really care about stare decisis if we think that's wrong. The thing that I'm worried about, and I think that this was a problem with Casey, in deciding Casey the way that it did, I was at a conference recently with Walter Dellinger, where he was saying that he and the folks who were involved in Casey at the time were somewhat disappointed, because had the court just come out and said, we're going to overturn Roe, it would have created such an uproar. The votes were in Congress at the time, where we might have gotten some federal legislation that protected the right. I'm worried that the court will do some sort of silent overruling of Roe and Casey, so that it is ostensibly still in place and obscures the damage that they're really doing to the right at issue, and then insulating themselves from any sort of political action in response to the opinion. I might be wrong about that, because I kind of think that the people who are the 5 who are in the majority on this maybe just don't care. Justice Alito gave a speech a couple weeks ago where it's clear to me that he views all of this sort of media attention and outcry about the court with a certain amount of disdain. So I'm very worried about where this goes and what it will do, the damage it will do to stare decisis.
So before we move on, we have a question from the chat that's also along these lines, asking what would it be like to overturn Roe but keep Casey in place? Could you see sort of dropping the fundamental right analysis from Roe and keeping the watered down version of the undue burden standard, which I should say some people would say is already the effect of Casey and then the 2018 Whole Women's Health decision, that is kind of where we are. But what do you think, Professor?
So I think that that's a possibility that they say. It almost is consistent with what the petitioners are arguing, right? Like so there is no constitutional right, but that's not to say that there is no standard here, right? We have to pass rational basis, and maybe like if there is an undue burden that is not supported by a rational basis, there's a problem with the law from that perspective. But so yes, I think the short answer to the question is yes, I think that's possible. And I think, again, it's true that that in some aspects is exactly what Casey did, right? It was a violence to Roe, but in a way that didn't look like it. And so I do think that's a possible outcome. And like I said, the question for me is how are they going to do it, not whether or not they're going to do it. I do think there will be damage, but this might be one way that they do it, is to say we're going to overturn Roe, but don't worry, because we're going to keep the undue burden standard, but then undue burden really doesn't mean anything. So.
Great, thank you very much. So I'm going to now turn it over to my amazing colleague, Mahogane Reed, who's going to talk about a few more of the key decisions that the court is going to be deciding this term.
Great, thanks, Sam, and thanks so much for having us, everyone. I'm going to discuss a few cases that are slightly less profile than the cases Professor Wright discussed, but that are really important to civil rights practitioners and really big civil rights cases that the court will hear this term. And I'll start with Cummings versus Premier Rehab Keller. So this case asks whether a victim of discrimination under Title VI of the Civil Rights Act of 1964 and other anti-discrimination statutes that incorporate Title VI's remedies can recover emotional distress damages. And just a bit of background, Title VI is a landmark piece of civil rights legislation passed under Congress's authority under the spending clause of the Constitution. And the purpose of Title VI was to ensure that public funds to which all taxpayers contribute are not spent in a fashion that encourages or entrenches or subsidizes racial discrimination. And so to further this goal, Title VI requires recipients of federal financial assistance to agree to not discriminate based on race, color, or national origin in exchange for receiving federal funds and federal financial assistance. The Supreme Court has interpreted this relationship as contractual in nature, which will be more relevant in just a second. But the Supreme Court has also held that if a recipient of federal financial funds is found to have violated its end of the agreement and to have discriminated against someone on the basis of race, color, or national origin, the victim of discrimination may sue for and recover compensatory damages. And since passing Title VI, Congress has passed similar legislation pursuant to its authority under the spending clause to prohibit recipients of federal funds from discriminating based on sex and disability status. And Congress has incorporated the remedies available under Title VI into the enforcement scheme for these statutes as well, such that victims of sex and disability discrimination can sue the offending entity to recover compensatory damages. So the facts of this case are that the petitioner, Ms. Jane Cummings, she's deaf, she's legally blind, and primarily communicates in American Sign Language. She sought out the services of Premier Keller Rehab for treatment for a work-related injury and other chronic back pain and chest pain, I think. She requested that Premier Rehab provide an ASL interpreter and explained that her disabilities prevented her from communicating through other methods, but Premier Rehab refused to provide an interpreter. And so Ms. Cummings sued under various anti-discrimination statutes, including the Rehabilitation Act and the Affordable Care Act, both of which prohibit discrimination based on disability status. And she sought emotional distress damages, among other forms of relief. And key in this, I don't know that I mentioned, but Premier Rehab Keller is a recipient of financial funds under the Rehabilitation Act. So the district court dismissed Ms. Cummings' claims and concluded in relevant part that emotional distress damages are unavailable under the Rehabilitation Act and the Affordable Care Act, and the Fifth Circuit affirmed. The Fifth Circuit relied on the Supreme Court's prior holding that given the contractual nature between the federal government and federal financial recipients under the spending clause, when determined under spending clause legislation, when determining what form of damages are available to victims of discrimination, courts should consult traditional contract law principles and determine whether the sought after remedy is traditional or foreseeable remedy of the breach of contract that the financial recipients would be on notice that they'd be liable for. And so under that theory, the Supreme Court has previously held that punitive damages are unavailable to victims of discrimination under the spending clause statutes because they're not a traditional remedy in breach of contract litigation. And the Fifth Circuit concluded that generally that the same logic compelled the conclusion that funding recipients are also are not on notice that by accepting federal funds, they're exposed to liability for emotional distress harm, because emotional distress damages are not traditionally available in breach of contract actions. So the Supreme Court will decide whether that's the case, whether emotional distress damages are indeed a form of compensatory relief that victims of discrimination can recover under Title VI and other anti-discrimination statutes that incorporate its remedies. And it's important because often emotional distress damages are the only remedy available to victims of discrimination by federal financial recipients. And historically, both before the passage of Title VI and after the passage of Title VI under various anti-discrimination statutes, courts have readily awarded emotional distress damages to victims of intentional discrimination. So the court will decide that issue, and will hopefully, the court recognizes the history of availability of emotional distress damages and will hold that the Fifth Circuit erred and will reverse. But that court will be argued in November, and we'll know the answer to the question later this term. So the second case I wanted to discuss is Cvs Pharmacy Inc. versus Stow. This case also concerns the Rehabilitation Act and the Affordable Care Act, but doesn't get to remedies as much as it gets to liability under the act. And it involves a dispute over how much protection the Affordable Care Act and the Rehabilitation Act provide people with disabilities. The question presented is whether these statutes permit disparate impact suits or discrimination suits without a showing of intentional discrimination against health insurers and healthcare providers under the Rehab Act and the Affordable Care Act. The plaintiffs in this case are HIV positive individuals who claim that the petitioner, CVS, which manages the prescription drug benefits for the plaintiff's health insurers, effectively prevents the plaintiffs from receiving adequate care for their condition by requiring them to use a specialty pharmacist to obtain some drugs, some specialty drugs, while simultaneously requiring many of the plaintiffs to obtain non-specialty drugs at other pharmacies. The argument and the legitimate fear is that requiring them to obtain drugs from two different sources will make it difficult, if not impossible, for CVS to track potentially life-threatening drug interactions and will lead to inadequate healthcare and heightened health risks. CVS has argued that it changed the way it dispenses specialty drugs to manage costs, and it didn't single out any specialty drug. It didn't single out people with HIV, but instead changed the way it managed all specialty drugs. And so it shouldn't be liable for discrimination under the Rehabilitation Act. And inherent in this argument that became explicit over time is that there is no claim for unintentional or disparate impact liability under the Rehabilitation Act. The district court concluded that the Rehab Act does indeed reach disparate impact claims, although it held that the plaintiffs didn't adequately allege that the change in the way their specialty drugs were managed would produce differential results for people with HIV because of their condition. And the Ninth Circuit agreed that the unique impact of a facially neutral policy could create liability, a disparate impact liability under Section 504, but disagreed with the district court and held that the plaintiffs had stated a viable disparate impact claim. So now the case is before the Supreme Court to decide, and the case will likely turn in large part on whether the Supreme Court believes the statutory text of Section 504 of the Rehabilitation Act permits disparate impact claims. And the relevant language reads that no otherwise qualified individual shall, solely by reason of their disability, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. And CVS has primarily argued that the statute's text, and particularly the language solely by reason of, focuses less on the effects of the challenged action and more on the reason behind or the intent behind the action, and thus precludes disparate impact discrimination claims where there's no indication of intentional discrimination. And so this case is important. The court's ultimate decision will be important, not only for its potential impact on these plaintiffs' ability to proceed with their challenge to these burdensome changes to their prescription drug benefits and care, which is really, life-saving care that they've been receiving, but also for the future of disparate impact claims under the Rehabilitation Act, and potentially more broadly than that. We know that intentional discrimination is difficult to prove, but that's very true, I think, in the disability context, where often healthcare providers and others in the healthcare arena, they don't act with necessarily with overt, blatant discriminatory animus against people with disabilities, right? But they act in more covert and even unintentional ways that make policies and practices that exclude people with disabilities from fully participating in society. And nullifying and eliminating those more covert acts of discrimination was one of the animating purposes behind the disability discrimination statutes, including the Rehabilitation Act. And so requiring a showing of intentional discrimination would be inconsistent with the aims of those statutes. That said, we've seen over the past several terms that many of the more conservative justices currently on the court have been hostile towards disparate impact suits in various contexts, where they interpret the statutory language as not supporting that form of liability. And even where the statutory language does support disparate impact liability, as we saw last term in Brnovich, there's still some hostility towards disparate impact litigation. And so there is real concern about what the court will do. And please pardon my dogs in the background. There's real concern about what the court will do with this case. And so we'll have to see how the court acts. But there's a lot of amicus support for the does in this case, just because getting rid of disparate impact liability in this context could work substantial harm on the doctrine and on the viability of the Rehabilitation Act claims generally. And then the last case I wanted to discuss is United States versus Vallejo Madero. I generally, I try not to overstate the importance or potential impact of any case, but this case is, a really important case that will likely define the scope of constitutional protections for Puerto Ricans and residents of other United States territories vis-a-vis residents of the 50 states and DC, and the extent to which Congress can abridge those protections. The case asks whether the United States denial of cash assistance under a federal program known as Supplemental Security Income, or SSI, to low-income, elderly, blind, and disabled Puerto Ricans violates the Fifth Amendment's Equal Protection Guarantee. And as you learned or are learning, or I think you will learn based on what Professor Wright said earlier, when someone challenges a statute as unconstitutional, courts will commonly apply one of three levels of judicial scrutiny: strict scrutiny, which is the highest and least deferential form of scrutiny that the court applies where the challenged law invokes a suspect classification like race or national origin; intermediate scrutiny, less demanding than strict scrutiny, and invoked where there's a quasi-suspect classification; and then rational basis review, which is the most deferential form of judicial scrutiny. And so this case primarily asks which of these levels of scrutiny will apply to the SSI program. But just a bit of factual background: the respondent in this case, Mr. Vallejo Madero, he was born in Puerto Rico. He moved to New York. He was born in Puerto Rico in the 1950s. He moved to New York in 1985. And while living in New York, he sustained a serious illness that left him unable to support himself. So he began receiving SSI payments in 2012 while he was still in New York. He moved back to Puerto Rico in 2013 to be closer to family and continued to receive SSI benefits when he moved back to Puerto Rico. A few years later, the government, upon realizing apparently that he relocated from New York to Puerto Rico, notified him that because he'd made that move, the administration would prospectively terminate his SSI payments and would also seek to recoup more than $28,000 in payments that the administration had said they overpaid him because he was no longer qualified to receive those benefits based on their argument once he moved from New York to Puerto Rico. So Mr. Vallejo Madero, he answered in federal district court after the government filed its suit and asserted that he wasn't required to return the payments because the denial of SSI benefits to otherwise qualified residents of Puerto Rico violate solely on the basis of where they reside, violated the Fifth Amendment's Equal Protection Clause. The government responded that Congress has plenary constitutional authority to manage and control all United States territories, and that its exclusion from Puerto Rico from the SSI program only needed to survive rational basis review. The government argued that it had adequate justifications. It would be costly to extend the program's benefits to residents of Puerto Rico, and residents of Puerto Rico don't pay federal income taxes, and so don't contribute to the general revenue funds and shouldn't receive the benefits of a program that they don't contribute to. The district court agreed with Mr. Vallejo Madero, though, notwithstanding the rational basis review advocated for by the government, and rejected the government's argument. The court concluded that Congress's plenary authority to manage territories was limited, not a basis upon which to deny Puerto Ricans a fundamental constitutional right to equal protection under the law. And the court also disagreed that regular rational basis review should apply, but instead held that more searching and less deferential form of rational basis review, often referred to as rational basis with bite, should govern given the political powerlessness of Puerto Ricans to democratically affect any change to the SSI legislation, since residents of Puerto Rico don't have any voting representation in the United States Congress. The First Circuit unanimously agreed in an opinion by the late Judge Juan Toruela, who was a staunch advocate for Puerto Rican equal rights of Puerto Rican residents, and explicitly held that the government's justifications for excluding Puerto Rico from the SSI program wouldn't survive any level of judicial scrutiny, not even the most deferential. So the case is before the Supreme Court, which could decide, any number of issues, which level of judicial scrutiny applied. Does a heightened level of judicial scrutiny apply to the government's denial of Puerto Ricans and residents of other U.S. territories from the SSI program? Whether the Fifth Amendment's protections or other fundamental constitutional rights extend to residents of Puerto Rico, which seems like it should be a no-brainer. And then whether the court will expressly limit the applicability of a set of cases known as the insular cases, which the government has in part relied on to justify differential treatment of Puerto Rico. And I've been going for a while, I'll be real quick. The insular cases, in a nutshell, are a series of rulings from the early 1900s where the Supreme Court held that the Constitution doesn't fully apply to territories acquired by the U.S. during the Spanish-American War, including Puerto Rico. I think it's well established that racism and prejudice and bias played an unambiguous factor in these rulings. And over the past 50 or so years, various factions of the court have indicated discomfort with and even disagreement with the insular cases and their perpetuation of differential treatment of Puerto Ricans. And so we'll see what the court does in this very, very important case. But those are my cases.
I'm going to talk about a few criminal justice cases. And actually, I'm going to start by going a little bit off script because the court this morning issued a couple of summary decisions in qualified immunity cases. So usually, as I think many of you know already, when the court decides a case, it first grants a cert petition. So in order to get the court to review a case, you file a cert petition, you're unhappy with the ruling of a lower court, and the court will say, okay, we're going to consider this case or we're not going to consider this case. And if they grant the petition, that means there'll be an opportunity for a full brief, a full response, there will be oral argument, and the court does all of that before it actually issues the decision. Rarely, although not extraordinarily rarely, because it happens a number of times every term, and an increasing number of decisions like this, as you probably read about in the shadow docket. the court just issues a ruling without going through that full process, and this is known as a summary decision. This morning, the court summarily reversed 2 decisions which had denied qualified immunity to police officers in excessive force claims under the Fourth Amendment. And I'm not going to get into the details of the cases, but if folks want to talk more about qualified immunity towards the end, we certainly can. But in both of these cases, essentially the lower courts had concluded that there was unconstitutional excessive force in violation of the Fourth Amendment that police officers had engaged in the course of arresting people. And in one case, the officers killed the person. And that one I'll talk a little bit more about. So the officers in that case were investigating reported crime. They come upon this person. It's a sort of an alleged domestic violence situation, and he has a hammer. And they, the officers say that he's sort of acting in a threatened way with a hammer, and they end up shooting and killing him. And the lower courts concluded that this was an excessive force situation. And the issue with qualified immunity that is challenging is that an officer or any government official will not be liable for conduct, even if the conduct is unconstitutional, unless the right at issue was clearly established. The idea, the theory behind qualified immunity is that officers or other government officials should be on fair notice that what they are doing is unlawful before they're subject to liability. And whether or not you think that is sort of a good theory or not, I think that one of the things that's been quite troubling for those of us who are concerned about the court facilitating, I'll say, or certainly not doing what it needs to do to remedy police misconduct, including police violence, is that the court has really interpreted that standard in a very draconian way, meaning that they're looking increasingly for situations where a plaintiff would have to say, oh, I can point to a similar case with very similar facts where you or perhaps the Court of Appeals found the same thing to be unlawful. And the reason why that's so problematic is that you often will have situations in the excessive force context in particular where the facts will change to some degree. You're not going to have the same number of officers. You're not going to have the same weapons involved. You're not going to have the same amount of time between when somebody did something and somebody did something else. And so the more you require a factually directly analogous case in order to overcome a qualified immunity defense, the more difficult it's going to be to hold officers accountable, even for very clear violations of the Constitution. And what was disturbing about the cases today was that the court really sort of doubled down on this idea that in most cases, especially under the Fourth Amendment, we really want very analogous prior cases, which makes it very difficult to hold officers and other government officials to account for unconstitutional conduct. The reason I want to talk about those cases a little bit was both because generally, I think qualified immunity is one of the most important issues that we're all watching and seeing sort of what the court does, especially given that Congress, at least as of now, has not done what it needs to do to sort of pull back on the doctrine. But I think more generally, one of the things that I feel like it's important to think about for those of you who are, pursuing a career in law is this sort of gap between a constitutional right and what the remedy is for a right. And I think that you saw both in Tiffany's presentation and Mahogane's presentation examples of this, right? So is the court going to do what it has been doing, which is perhaps maintain that there is a right to abortion, at least in certain circumstances, but make it so that it approves laws that essentially take away any remedy? In one of the cases that Mahogane talked about, Cummings, we have these statutes that clearly prohibit racial discrimination, sex discrimination. But if the court says, well, there's no remedy for purely quote emotional harms, it means that actually a significant class of cases, there would be no remedy for a violation of the right and no remedy for the stigmatic harm or dignitary harm or whatever sort of term the case law would suggest, just for the act of being the victim of discrimination. And so in all these areas, if you sort of look across, I think one of the most important issues in terms of assessing sort of the state of the rule of law and the state of the court is how big is there a gap in general between rights and remedies, and who are the people in our society who are the victims of that gap? And I think if you look across the board, you will see that the court privileges certain kinds of rights and certain kinds of people in asserting rights and making sure that they have remedies, and it disadvantages others. And so the cases that I was going to talk about, and this is why qualified immunity was such a good segue in a way, are all cases involving the rights of incarcerated persons. And I think if you look across the law, the sort of group of people who, or one group of people who are consistently subject to the biggest gap between the stated right and the remedy for that right are people who are in prison. The first two cases I want to talk about are both going to be argued on November 1st, so they're pretty soon. And they're both involve capital cases. The first one is, I think, actually one of the most important cases of the term, although it hasn't received the attention. And this is one of the challenges because it is sort of like a very dense legal issue in a lot of ways. But the ultimate idea is actually very relatively simple, straightforward, and also extremely important. The case is Shin versus Ramirez. And Shin versus Ramirez actually involves two companion cases. I'm going to focus on the facts of one of them because they are so significant from my perspective. They involve a person on death row in Arizona named Barry Jones. Mr. Jones was convicted and sentenced to death for felony murder in connection with the death of a 4-year-old child who's the daughter of his living girlfriend. And the prosecution's entire theory of the case depended on the possibility that the victim died as a result of an injury that was inflicted, a traumatic abdominal injury that was inflicted when she was in Mr. Jones's care very briefly the day before. So that was the entire theory of the case. Under the Sixth Amendment right to counsel clause, one of the most important things for Mr. Jones was to have an attorney who could defend him at the trial. And the Supreme Court has made very clear that the Sixth Amendment right to counsel doesn't just mean an attorney who is a warm body sitting next to you. It means someone who can actually subject the prosecution's case to adversarial testing and to fairly protect the defendant's rights. That right was clearly denied to Mr. Jones. His attorney did not even do any sort of investigation and didn't have the experience, frankly, to do any sort of investigation into the prosecution's case. So his attorney did not discover evidence that would have shown or strongly suggested it was scientifically impossible for the case to have unfolded, as the prosecution said, because actually these injuries to the victim happened before she had ever been in Mr. Jones's care. And if that was true and believed by the jury, then there would have had to have been an acquittal because Mr. Jones simply could not have committed this crime. The problem for Mr. Jones is that this evidence was not uncovered until federal habeas proceedings. When you have criminal cases generally, and this happens certainly in capital cases, there are really sort of 3 stages to the case. There's the trial and the first appeal. And then there's something called the state post-conviction proceeding. And that's your opportunity to present a new claim based on evidence that wasn't part of the trial record. So if you want to show, hey, my trial lawyer was just fundamentally incompetent, you need to present new evidence. And the way that the first opportunity you have to do that is in the state post-conviction process. But Mr. Jones' state post-conviction counsel was incompetent, just like his state trial counsel. Again, these are lawyers who are appointed by the state. It's not like he was in a position to hire his own lawyer, so he didn't have anything to do with these choices. And so his state post-conviction lawyer doesn't do anything to present the evidence of his state trial lawyer's incompetence. Gets to federal court, federal habeas, and he's finally appointed a qualified attorney from the Federal Defenders Unit in the state of Arizona. And they present all this very powerful evidence. And the state says, you have a problem because you didn't present that for the first time in state court. And under a very controversial law that President Clinton signed in 1996, the Anti-Terrorism Effective Death Penalty Act, in general, evidence has to be presented for the first time in state court, or it can't be considered at all. There's supposed to be an exception to this principle if it is not the fault of the petitioner that the evidence wasn't presented. But the state says that exception doesn't help you because you are bound by the errors of your state post-conviction attorney, even though you could show that your state post-conviction attorney was incompetent. A few years ago, the Supreme Court decided this case, Martinez versus Ryan. And the logic of Martinez would very strongly support Mr. Jones because he created this opportunity for people in the federal habeas process to say, look, the reason I didn't present something better in state court was because I had an ineffective state post-conviction attorney. But the state is arguing that that Martinez decision didn't directly take into account this provision of the Anti-Terrorism and Effective Death Penalty Act. It's a sort of a, I suppose you could say, a clever argument by the state, but it's clear that essentially the outcome if the state were victorious would be to overrule the Martinez decision, which in turn would make it so it was in many cases impossible for people with very meritorious claims to be able to litigate them in the federal habeas process. So this is a really important case from my perspective, and one that will really sort of test going forward this gap between rights and remedies for incarcerated persons who are trying to show that their conviction, or in capital cases, their death sentence, was fundamentally unfair for reasons that, through no fault of their own, they were not able to present in the state post-conviction process. The other capital case that's going to be considered on November 1st is Ramirez versus Collier. This is the latest in a series of cases about condemned persons and their access to spiritual advisors during an execution. In February of 2019, there was a very controversial decision, 5-4 decision. This is when Justice Ginsburg was on the court still, that divided along very traditional ideological lines, where the court lifted a stay of execution for a man named Dominique Ray. And Mr. Ray was asserting that the state of Alabama had violated his rights under the First Amendment because they were sort of discriminating against his exercise of religion. He wanted to have a Muslim spiritual advisor with him in the execution chamber when he was executed. And the state would permit a Christian spiritual advisor, but for no good justification, they would refuse any other spiritual advisor. And the court nonetheless denied, or I should say overturned, a stay that the 11th Circuit had entered in Mr. Ray's favor. Very controversial, led to a real outcry of criticism. And just 1 month later, the court essentially reversed course in a case from Texas where the condemned person is named Patrick Murphy. Texas had a very similar policy. Mr. Murphy was Buddhist, and he wanted a Buddhist spiritual advisor with him while he was being executed. And Texas, the law was a little bit different. They would permit either a Christian or a Muslim spiritual advisor, but no other spiritual advisor. And the court said, no, this is religious discrimination. And to try to sort of justify the distinction, Justice Kavanaugh, who had been in the majority in the previous case as well, and was in the majority in this case, said, well, there were some differences in the timing of when the claim was presented and the sort of nature of the arguments. I think, candidly, it was sort of a dubious distinction, but that was the distinction that was drawn between the cases. What the states did, or at least what Texas and Alabama did in the wake of Murphy, was to say, you know what, fine. We're just going to have a policy prohibiting any spiritual advisors from being in the execution chamber during an execution. The problem for the state with that approach was that there's this federal law from 2000, the Religious Land Use and Institutionalized Persons Act, which you heard a lot about scrutiny from both Tiffany and Mahogane. That's a federal law that essentially does something somewhat unusual and creates a strict scrutiny standard as a matter of federal statutory law whenever a prison or certain other recipients of federal funds does something that substantially burdens the exercise of religion. And essentially it puts upon the state the burden to justify, why are you substantially burdening this religious expression? Is there another less restrictive means that you can use? So the states, had a challenge because they had previously been allowing spiritual advisors in, and they sort of just shut it down because they didn't want to deal with the fact that they could no longer discriminate in the way they were allowing spiritual advisors in. So the court ruled in favor of a couple of additional condemned persons as a result of these RULIPA, it's the name of the acronym of the statute claims, and set aside some additional executions. That leads us to the case that the court is actually considering, which is Mr. Ramirez's case. In Mr. Ramirez's case, the issue is not access to a spiritual advisor. Texas is allowing a spiritual advisor into the execution chamber with Mr. Ramirez. But they're saying that the spiritual advisor cannot hold hands with Mr. Ramirez and cannot pray with Mr. Ramirez while he is going from one world to the next. And Mr. Ramirez says, this is another RULIPA situation. You're substantially burdening my exercise of religious rights without any sort of safety or other compelling justification. So the court stayed his execution and granted cert to consider the case on an expedited basis. But to sort of return to this theme of rights versus remedies, The court then asked the parties to address several additional questions besides the merits. One of them is, did Mr. Ramirez exhaust his claim under the Prison Litigation Reform Act? Prison Litigation Reform Act is a law that was passed very close in time to the Anti-Terrorism and Effective Death Penalty Act, which we talked about earlier, which makes it essentially that in almost every case, in order for someone who's incarcerated to have their constitutional rights vindicated, they first have to present their claim to an internal prison grievance system. And you might say, well, that's nothing wrong with that. It just gives the prison an opportunity to consider the claim first. But prison grievance systems are often very difficult to navigate. They often have extremely short deadlines, and they can be very confusing. And so if you, through maybe a good faith mistake, file a grievance 8 days later when there's like a 7-day deadline under the grievance system, or maybe you're worried about retaliation, so you don't initially file a grievance, those kinds of things could mean that your claim is forever barred from federal court. So that's one of the issues that the court is going to be deciding in the Ramirez case as well.